My iPhone says 12:45. So I think we are ready to get started. Everyone who's in their seats got here on time, and I appreciate that. So just by way of introduction, my name is Dan Wurtzel. I'm the president of First Service Residential. And to my left is Ben Kirschenbaum, vice president and general counsel of First Service Residential. Ben will be speaking, I promise you. What we're going to do today, first of all, I just want to make sure everyone is in the right seminar. So if you look at the screen, if this is where you intended to be, you're in the right place. If not, you have an opportunity to leave or actually stay and listen. So for this afternoon, what we're going to do is Ben and I are going to have just a conversation about some of the key topics as it relates to listening to your managing agent. And also kind of weaved into that is some liability issues and some traps that boards can get themselves into. And so the goal is to probably do that for about 50 minutes or so, and then maybe have 10 minutes for Q&A. So I hope at 1:45 or 1:45, all of you walk out of here with some nugget of information, something that's going to resonate that you can take back to your boards and hopefully implement down the road. So these are the areas or the topics that we're going to talk about this afternoon for the next hour. Avoiding liability exposure, quality of life disputes, and conflicts of interest. And just as sort of a summary, I think that I've been in this business for 33 years. Ben has been doing it a little longer, I think about 36 years. And over that time, there's been an evolution in the property management industry. It's gone from a relatively simple business to a complex business. Performance is continuing to move up. The demand from our boards for improvement is increasing. And how we work with our boards to achieve our goals is critical. And the relationship between property management and a board is a partnership. And that's how it should be looked upon, because that creates a good rhythm of a relationship where you can get things done. So I've seen a huge change over the years. Ben, has also seen those changes. And for those of you who have been longtime board members or certainly in co-ops or condos for, a few decades have seen those changes as well. So before I get started more formally on the avoiding liability talk, Ben is a very passionate New York Giants fan. And I want to ask him, do you pick a quarterback or a running back with the second pick of the draft?
I'm good with Eli for a couple more years, so we're looking somewhere else.
Okay. I had to get that out of the way. If those of you who are not football fans, I apologize for wasting 30 seconds.
But I can add, Dan's very, very happy with that because he's a passionate Jets fan, and he wants more quarterbacks available for him.
Correct. Okay, so avoiding liability as board members, I think, falls into three buckets. And these are the three buckets that we sort of identified as really compelling areas for boards to be aware of. And we're going to drill down into each one of them, working with your professionals, understanding and consistently following and enforcing rules, and then email use, which may sound somewhat innocuous, but we're going to get into that, and we're going to show you some of the pitfalls that happen with emails. So, Ben, boards and managing agents, rely on their building professionals. How do you kind of bring them into the equation, these building professionals, in terms of their roles in working with boards and with managing agents?
Well, first, as Dan says, I'm an attorney, so I come with that background, and I always think things through as a lawyer. And so before I became involved in real estate and co-ops and condominiums, I was in corporate law, so I dealt with boards of directors. And all of you board members, I know, took the job because of the good pay. But you come to your boards with different experiences, different business backgrounds, and not necessarily business backgrounds, other professions, other trades, whatever. And as a board member, the expectation of a board is that you come with a basic intelligence, an ability to analyze problems, but you're not expected to be an expert in any field that managing of your co-op or condo involves. So your goal is to seek the guidance and help of professionals. And clearly the first one, because they're there as your guiding light, is your managing agent. So you want a managing agent who's going to help you get the information you need to make a decision. And that involves all of these professions that are out there. A lot of them have booths out there today, but whether it's your accountant, your own attorney, your engineer, your insurance broker, they're the people who need to come to you with information and advice so that you can ultimately make the decision. You're the ones who make the decision. And going back for any other who are lawyers, all of you are working with the basis that in order to avoid liability, if you use good business judgment, your decision will be upheld by any court or anybody who is trying to knock down your actions.
You know, it's interesting. Around that, using good business judgment, I know that boards, because I'm on the management side, I'm not an attorney, sort of grapple with, are we setting precedent when we make this decision? Because somehow boards feel that if they make a decision about a specific issue today, that's sort of set in stone for decisions that have to be made down the road. And do you kind of agree or disagree with that?
Well, every decision has repercussions, and you don't want to make a decision lightly because it will impact the thinking of your board, the thinking of your owners, the shareholders or unit owners. But you shouldn't be afraid to make a decision because it sets precedent. Hopefully, it's a good precedent that you want to follow through. And here, it's being consistent. Analyze your facts and come to a conclusion. Take your action and then move on, and next time you come up, if it were ever an identical set of circumstances, hopefully you would come to the same decision.
Okay. Now, sometimes what complicates issues with professionals is when you have similar professionals on the board, all right, and then they are certainly want to be considered subject matter experts on whatever that issue may be in the profession that they're in. And so how do you deal with that, and what should the role of a professional who's on the board be in these types of situations?
Well, I coincidentally was talking with a board president of one of our buildings a little while ago, and she happens to be an attorney. And preparing for this, I decided we would talk about this topic, and she agreed with me. Everybody comes with their own expertise, but as a board member, you should not be taking that expertise and necessarily telling the board, because I'm an attorney, this is the way we should do it. You should still get outside advice. And using another one of the sports analogies, since we started with the football, I'll go to basketball. I mean, if you're an attorney and there's a question that's a true layup, then go ahead, say to the board, you know, I've dealt with this. It's an easy one. It's a legal matter, but we know the answer, or I know the answer as an attorney because of my experience of practice. But there are very few real estate attorneys with co-op condominium expertise who are sitting on boards, and I think most professionals should step back and say, let me put my board member's hat on, use that good business judgment. And I know it's financial issues always come to pass, but you're much better getting an outside expert who's been retained to provide this professional advice for the board, because an attorney as a board member who makes this advice sort of opens them back up to some of that liability we're trying to avoid.
And I think lastly around this, there's a little bit of a triangle relationship here. You have the board, the managing agent, and then your building professionals. And you just want to explain how sort of the integration and the relationship would work, because, sometimes, we see boards that are going directly to directly to one of their building professionals. Sometimes we see where it's the managing agent who's dealing with the building professionals. In your professional opinion with building professionals, how do you see the relationship as really most effective in this application?
Well, your number one professional is your managing agent, and the reason you have a managing agent to be responsible is all of you are volunteers. This is not your full-time job, so you want your managing agent fully involved in all of your interactions with professionals. So they should be taking the lead in going out, soliciting opinions. But these professionals are really working directly for you, so I have no problem with the fact that the professionals come to a meeting if necessary, or one of the board members becomes the liaison with that professional and talks directly with them. But you can't exclude your managing agent, or you're not getting the most effective use of all of the parties that are there to give you that advice to make the decision. Okay.
So I think that was a pretty healthy discussion. We're going to open up for Q&A at the end so I can get through this. I did see a hand pop up. But I'd like to just kind of move on now, and understanding, which is the next topic, is understanding and consistently following and enforcing rules. And rules are, for co-ops and condos, are bylaws and house rules. And what I have seen, in my experience, is that, there are board members who may not even really understand the house rules and the bylaws. I know that boards react emotionally to situations that come up in buildings. Somebody is violating a rule, or they don't like the behavior of this person, and it's like, we want to fine them, we want to hang them or her, we want to just, this is awful. And I get it. These are your homes. You're living in a situation where it's not your, a single family house. You have neighbors upstairs, downstairs, to the left, to the right, across the hall. And anything that goes on with neighbors in a building is going to affect the quality of life. And, whether it's a 10-unit building or it's an 800-unit building, the chances are these issues do come up. And so, Ben, just really from a board's role in understanding bylaws and house rules, what kind of advice can you give?
Well, you have to become familiar. Again, as a lawyer, whenever I get involved in an organization, the first thing I do is look for those bylaws or rules, and you should become familiar with them. It's a good sleep aid if you want to read them at night, but seriously, if you're new to the board, if you've been on the board and haven't looked at them in a long time, pull out the house rules are dealing with more of your day-to-day operations. The bylaws deal with things that you might want to prepare for at an annual meeting, or if you're considering some major change, construction in the building, or other sort of fundamental operations of the building that you might want to look at the bylaws, because they do provide guidance. And they're not always perfect, but at least you need to understand where the board wants to go or what they want to do, and are there any inconsistencies? Because then you need to bring in some professional advice and see how you work through those.
Yeah, and so that kind of leads into, consistency between, I guess what the rules say and how the board wants the building to be run. And but I know that in many situations that could be different. And, how do you bridge that gap?
Well, that's always the fun or interesting part, not necessarily fun, but that bylaws and house rules, they're not something that you want to change every month because there's a new flavor that you want to address. But there are times when we look at bylaws or house rules that were developed 20, 30, or 40 years ago that really don't reflect the nature of the residency by your owners today. So if there's something fundamentally different, then that's the time to look to amend the bylaws, which is not necessarily an easy task given the need to get owner approval. House rules the board can implement if there's a clear need to change them. But going back to what you said, you want to have something that's consistent. So looking at those bylaws or house rules and following their guidelines as you deal with a specific issue, that helps you become consistent. You've got that basic bedrock to go back to.
And then I think to kind of tie this all together, the enforcement of these rules sometimes loses some of its consistency, and specifically, what I have seen over the years is a shareholder or a unit owner violates a house rule, and they're immediately given a notice, cure this or else. And sometimes if it's a board member, it's not handled the same way. And I don't, or it doesn't have to be a board member. It could be somebody who's close to somebody on the board, and you want to give them a break, or you want to just deal with it in a different manner. And I think that can lead to trouble, because what you have to do, and this is sort of the theme of this particular area, is consistently enforce your rules, because you'll get into trouble if you just inconsistently enforce rules and just apply them in certain situations. So, hard for you to disagree with that, correct?
No, and that's the one thing is we're still on the overall topic of liability. As I discussed, the board is protected by a business judgment rule, but the only time business judgment can be questioned is if there's some self-interest by the board member, and obviously if it's a fellow board member who violates a rule, and all of the other board members say, well, Joe's been a board member, he's worked hard for the board, let's sort of overlook that. The next time when you go to enforce it, surely somebody's going to know how you treated Joe, and if you treat that person differently, then you're opened up to potential problems.
Okay. I want to move on to email use. And I'm going to start out by giving you a brief story on something that happened to a board member who I knew very well when I was managing buildings. And that board member was using their work email address, and they were corresponding with other board members about a legal matter about another shareholder. And the matter ended up going to litigation, and this person's emails were subpoenaed. And the subpoena went to their employer, and obviously the employer had to comply with the subpoena, which they did. And I don't think there was anything incriminating in those emails, but the individual lost their job, was fired. And it was more of not realizing that they should not be using their work email, for other uses besides work. And that is, and you know, thankfully this person was able to find another job, but it was a very upsetting experience for those who were involved, both by the board and by my organization. So I think the first thing is, you know, Ben, what kind of email should you use? I mean, obviously, work is a no-no, and there are risks involved if you use your work email address. But what's your opinion?
Well, I spend 110% of my time on work, so I don't need another email address, but I also don't sit on a co-op board or a condominium board. Clearly, if the board is able to create its own domain name, and you could get at the xyzcoopboard.com and have each board member, that would be, in my mind, an ideal way to proceed, because it gives the board some control. And so if John goes off the board, that email can be shut down, but you've preserved all of the emails that he has used during his tenure on the board. But otherwise, set up a separate account. John Board account at gmail.com is fine, and use that for all of your co-op or condo board business.
Yeah, and you know, we're also asked on occasions, well, I'll use my personal email. You know, I got my Gmail account, my Hotmail account, Yahoo, whatever you have. And the problem is if something happens and emails need to be subpoenaed, you know, you got to turn it all over, and maybe there's something in there that, you know, is inappropriate that you don't want the outside world to know. And so, you know, however you like to communicate on your personal email could be subject to the eyes of counsel in some sort of litigation. So that is why we recommend to our board members to do exactly what Ben said. Either if you can set up a domain, great. If you can't, just set up a separate email account for conducting board business, and just, you know, I know it's another sign-in, another login, but you know, you want to reduce your risk, and you're better off being safe, because everything's good and fine until something goes wrong, and then it's a mess. So the next kind of area around emails is really what should be communicated via board members through email. Because let's say you have this separate email, great, congratulations, you've now segregated that out. But there's still some other risks, because there are certain things that should not be communicated via email, because it's a permanent record, and I have seen boards get into hot water over this. So Ben, you want to just kind of expand on that?
Well, again, going back to my training, boards make decisions at board meetings, and that's when you should make decisions. I mean, I remember before participation by conference call was permitted, but now most boards have a monthly meeting. They can call a special meeting, freeconferencecall.com. That's where you make your decisions. Emails should not become a chat room for what the issues are, going back and forth and trading information. It creates that permanent record, and some things are better left unsaid, or at least unrecorded. But emails are effective means of communicating information, and so certainly I have no problem if you tell your managing agent, we need to get the copies of the 3 proposals to do the roof replacement or whatever other project, and get that email, have it distributed to all of the board members so that everybody has the same information. That's a critical and very useful means of communicating via email. Setting dates, anything that's administrative, setting dates for your meetings, finding out availability. The great thing about email is you don't need the simultaneous communication that you must have at a board meeting where everybody's there together. So your manager could send out, are you available next Tuesday for a special meeting at 5 p.m. to 7 board members? It may take 2 days for the people to come back to you, but you at least get all the information, and then you can move forward.
Yeah, so just to kind of reemphasize, the managing agent's role in emailing with board is to distribute information and also to provide updates. I think from a board's position, you want, if there are yes-no decisions that don't require any kind of sidebar explanations, proving an application, okay, that can be done. But certainly if there is an issue with an application, all right, I mean, that should never be discussed via email. That can get you into trouble. Setting dates and times for meetings, interviews, subcommittee things, those are certainly, clean types of emails that boards can use to communicate with each other. Circulating status reports if a board member attended a construction meeting. There's a weekly construction meeting, and that board member is the liaison with the rest of the board to provide an update. That's okay. And just, it's really common sense. I mean, that's what I can fall back on. If you are getting in front of your keyboard and you start to, type out some things and it doesn't feel right, something tells you it's not right, don't send it. Okay? Go with your instincts. You're better. Once you hit send, you can't pull it back. I mean, I've seen these emails come through from board members, and then a minute or two later, such and such would like to recall the email that they just sent. Well, that's great, but it doesn't mean it's erased. It's still there. So those are just really some good pieces of information and advice that we can give you around email.
I was going to add, because I thank Dan. We had a leadership training last week, and emails came up as part of leadership. And it as Dan said, we've both been in this business for more than 30 years, so we remembered before emails. And I sort of had this epiphany. I said, the email today has become what the handwritten letter or typed letter was 30 years ago, but I don't ever remember sending 100 letters out in a day. I thought about, I'm trying to get down to 5 emails a day, like I used to send no more than 5 letters a day. Pick up the phone and talk to your fellow board members.
Okay, so I'm going to shift gears to the next category. Quality of life disputes. This is a big area in our lives as property managers and as board members. You probably can add a dozen more bullet points, but time is of the essence, so we just wanted to kind of hit a few that we've seen that become hot button topics with boards. So the first one is pet policy, all right, which is near and dear to a lot of buildings. But I think first and foremost is, know what's in your house rules, all right? I've been in situations where a building says we are a no pet building, okay? And they've been following that, and that's what the brokerage world knows. And when an applicant is submitting for a purchase or a lease, there's, do you have a pet? Yes, no, and then, they want a little description. And then they're like, well, we're no pet building. Guess what? It doesn't say anywhere that you're a no pet building. It's not on your house rules. So, number one is kind of know your rules and make sure that as it relates to pet policies, it's consistent and you're aligned. Even if you don't like it, okay, you still got to follow it. And there obviously are ways of changing rules, but for the most part, not for the most part, but if you have in theory, a no pet policy in a building that doesn't have a written rule about a no pet policy, it's not enforceable. And again, everything is fine until somebody challenges something, and then you got a problem. So in terms of changing policy, what do you think? What do boards have to do to kind of effectuate a change?
Well, I go back to the term. Excuse me for the condominium owners, but cooperatives. The whole idea, if you read the history of cooperatives, was that it was people who had similar interests, similar tastes, etc. So if you're going to change a house rule or policy, whether it's a pet policy or otherwise, hopefully the board knows their constituency, and you do talk to your neighbors, etc. Because if there's a no pet policy, and that was truly what everybody wanted, and everybody still wants it, there's no need to make a change. But if there is a change in the circumstances, you really need to know what's going to be the impact, or what's the reaction of all of the residents. Certainly, a pet policy, which is probably a house rule, not a bylaw, the board has the legal authority to impose any policy that they want. But if you want to have an uproar, do something that's contrary to the vast majority of your owners, and you'll have a real issue.
Yeah, and another area around this is fines. Okay, Fido's got to use the service elevator. All right, and for one reason or another, the dog walker comes in and uses the passenger elevator because the dog walker doesn't know, or just is in a rush because they have a whole bunch of dogs, and boards are like, all right, we got to fine them. All right, it's $50, $100, but where does it say that you can fine somebody? And you have to make sure that your rules are comprehensive, and that you're playing within the boundaries. All right. I know that having a dog relieve themselves, defecate, whatever in a hallway is just miserable, and it's nobody wants that, even in a pet friendly building. But you have to make sure that the policy in place is consistent with your house rules. These things should be written by your in-house counsel, so that you have a solid pet policy rule that if there are fines, for what, and everything is spelled out so that your owners are aware of the policy. Now, if you have a policy that has all this spelled out, and an owner says, gee, I didn't know that Fido shouldn't relieve themselves in the hallway, and I would get fined for it. Well, that's not, that's not a defense. All right, you have the policy. It's when you don't have a written policy and you try to enforce a policy that you can get yourself into some hot water. And I don't know if there's anything that you want to add to that, but
no, I mean, the only thing is communication. Probably everybody, when they bought their apartment or applied to purchase their apartment, acknowledged somewhere that I got a copy of the house rules and I read them. But their memory's about as good as mine, which means about 2 days later, unless there was some specific issue that they were looking at, they've forgotten those. So I think we all assume everybody knows the house rules. Not necessarily, but on some periodic basis, let's inform people, remind them. Probably best not when there's immediate violation, because somebody will think that it's pointed at them, but just as a matter of course, put it in practice, talk to your manager and say, look, once a year we should remind everybody of these policies because they're important to us.
And then I think the last piece of this is really, having rules that are reasonable and make sense for your building versus unreasonable. So, and I'll give you like a bizarre example just to try to make my point, but Fido and all dogs have to use the freight elevator, when they're leaving the building and coming up. But the freight elevator is not operational from 11 p.m. to 6 a.m. or whatever the hours are. Dog wakes up at night, it's got a bad belly. What do you do? So you have to have reasonable rules around pets. It's a quality of life issue. The next issue, all right, which has become, I think, a real big hot button issue over the last, I would say, 10 years is support animals. All right. It seems today that it's just as easy to get a letter that you need a support animal as it is to go and buy a thing of Tylenol at a local, Dwayne Reed or CVS. I mean, that it's become that easy. And so, what, Ben, I've been babbling for a while. I'm going to have you step in, but what are reasonable accommodations for this type of request?
Well, it's become and the scales tip and balance in different ways. And as Dan said, over the course of the last 10 years, I think this has become an area where boards have less and less opportunity to put up any fight to a support animal. Again, having a policy and making sure everybody knows it. I think this is, again, something to remind everybody because people constantly have changes. But the first thing is if a pet or support animal does not comply with your existing pet policy, it should be made clear that there's a process. And that process you and your attorney can go into on more detail, but it requires a request of the board for permission to, in effect, obviate the policy because of the need for an emotional or support pet for whatever reason. And again, starting to, with your attorneys, establish policies because every day we see in the news a different type of emotional support pet. We've got peacocks, hamsters, etc. So there are lines that you're likely to be able to draw, but the important thing is to make sure people know that there's a process because too often it's when the owner gets a letter that says you're violating our pet policy, they say, well, I just wrote away, I'm going to have a letter to say that it's a support pet.
And
no, if somebody needs a chair, go ahead. Go ahead.
all right, so around that, of course, having a policy creates clear borders and defines what is permitted. One of the things that you want to avoid, maybe not, but this is something that I would want to avoid, is somebody comes and says, I need an emotional support animal, and this is a 120-pound pit bull, all right, in a no pet building, all right. So and what you have to do is you have to make reasonable accommodations, and without getting into litigation about what is reasonable, if you have a policy in place on what types of support animals would be acceptable, and that's a reasonable policy, then you're safe, all right? But when you don't have a policy, then it becomes a little bit more difficult, and it's higher risk when you receive a request for a pet, or somebody wants a pet donkey, or because that's the doctor said that would be great, great support animal for that individual. So really the next thing is okay, what do boards do, right? So the managing agent gets a letter, or maybe it was something went to the board president. What are the steps that boards, managing agents to take so that this doesn't sort of happen by default?
So my brethren have all prepped me for this. The first thing is call your professional, call your attorney. But here and do that through your managing agent, because if you get a request and again, depending on what your policy is in this area, I think you should always consult your attorney because at that point you can hopefully keep this not as an adversarial proceeding, but as one where you're interactive and you're working with this person who has a need, or at least professes to have a need, and you work through it with them and ultimately make that decision with the advice of counsel as to how to best protect the co-op or condo.
And do you recommend a time frame for a response, whether it's coming from the managing agent or building counsel upon receiving a request?
Well, I think you've got to respond very quickly because I don't know of any time limits on this, but the obvious first is whether that person has already got the pet in the building, and this is or this is a request in advance of obtaining or bringing this pet into the building. So this is one that time is not your friend. Sitting and waiting will not make it any better.
Okay, and certainly responses should be in writing, not over the telephone where there's no record of it.
Yes.
Okay. Again, we could spend a lot of time on each drill down even a little bit further and get more granular, but I'm trying to hit as many topics as I can within the time frame that we have. So kind of moving on, another hot button topic is smoking. All right. And again, over the last 15 years, the tolerance for smoke within a building and moving from apartment to apartment has become more heightened, and for good reason. And there's actually a new local law regarding smoking policy, and some of you may or may not know that. But Ben, do you want to elaborate on that?
I mean, have you been listening to your managing agent, and are you all aware that there's a new law that effectively requires every residential building, whether it's a rental, co-op, or condo, to adopt a smoking policy? I mean, having read some of the legislative history for this, this is couched in the form of a consumer information, so that every new resident of a building knows what that policy is. But clearly, the design here is to have, whether it's landlords in rental buildings or boards and co-ops and condos, adopt a more restrictive policy. So here's your opportunity or necessity for the board to look at any existing smoking policy, which, if there is one, you can just use that policy, and there's a publication, and I won't go into the gory details. But it's also the opportunity, and this is what the crafters of the law hope, for the board to look: is there a consensus? Is there an ability or a desire among the owners to adopt a more restrictive policy?
Yeah. So, a lot of boards have now taken this new local law and said, "Great, let's go for that no pet building, because that's what ultimately no smoking building, because that's ultimately what we want." And so, what can boards do? I mean, what are the parameters around this in terms of what a board has authority to do in terms of a smoking policy?
Well, that's the one where you really are going to need local or your own counsel to look at your own documents. I mean, I think generally my statement is that if you want to restrict smoking within an apartment, which is the ultimate no smoking building, you probably need to amend your fundamental documents, a proprietary lease in a co-op or bylaws in a condominium, which requires the owner's approval. Policies that relate only to common areas, I think you can do as a house rule, so a board could do it. So you've got those differentiations.
Right, and generally a house rule will have some sort of vague and general language about odors and noise and things like that, and basically it says you can't create these unreasonable odors and noises that disturb other owners in the building. And so that's sort of your boundary, all right? And you have to work with your counsel to craft a policy that complies with the local law and also is consistent with your building house rules. And so, you know, that's the key takeaway from here is, well, first is knowing that this rule, this local law exists, and B, working with your general counsel on crafting a policy that will work for your building. And most buildings will have pretty much the same type of policy unless there are certain nuances in the bylaws around, you know, smoking. But when buildings that converted to a co-op, you know, 30 years ago, or you know, back in the early mid 80s and early 90s, are probably antiquated, didn't address this issue, and so there's not a lot of leeway in tightening up the smoking policy for the building because the bylaws just don't permit it. So that's a little bit on smoking. I'm now going to move into our last category, which is another thing that just really came out in terms of a new law, and it's conflicts of interest. So, Ben, what is the law? What is this conflicts of interest law about? And conflicts of interest this just didn't come up. There conflicts of interest have existed. They exist on all boards, not just in co-ops and condominiums, but also in the corporate world as well.
Right. So this has been part of the business corporation law, which most all of our co-ops are formed under. And there has existed for as long as I can remember, basically a law that describes exactly how boards have to proceed if one of their directors has a conflict of interest. And by conflict of interest, does that director have a financial interest in a transaction that's being considered by the co-op or condominium? The simplest one is one of your board members happens to be a plumber, and you've got a plumbing job, and that board member has bid on that plumbing job. That's pretty straightforward. And the law has always been the same. That board member must recuse himself from voting on that decision, and that's, you know, if that's done, you've done the right thing. But now we've got what's new, and again, another consumer protection law that starting this year, every transaction where there's a conflict of interest must be recorded, and you as a board must report to all of the owners once a year on all such transactions, and if there are no transactions, that there were no transactions where there was a conflict of interest. That law that was passed late last year clearly applies to all co-ops. There's an amendment that's still waiting for the governor to sign, as of the last I heard, that will make this applicable to condominiums. So we've recommended to those boards that are listening to us, whether they're co-ops or condos, that they have to start to record. And that means, one, the board members have to still step up, because it's not necessarily the managing agent and maybe not even the other board members who will know if a board member has a conflict, but state that, and then in the minutes of that meeting, how everybody votes, and hopefully that the person who has that conflict of interest has not voted on that decision.
I want to just kind of drill down on a conflict that we've seen, and maybe some of you have seen as well. A broker is on a board, and they they have a deal. All right. Now, on that deal, that sale, they're going to be paid a commission, most likely by the seller, but those proceeds are not necessarily being paid by the building, so it may not be a conflict as defined by the law, but they may have an interest in seeing that an applicant gets through the approval process. So I don't know how you define that, and if it's a little bit of a gray area, I think that's okay to kind of tell the audience as well.
Yes, I mean, this has been topics of discussions among all the attorneys in the co-op condominium field. I think right now the majority of attorneys would say that that transaction does trigger the conflict of interest, but I certainly will say it's not unanimous. I have never seen a case, because as I said, the conflict of interest law has been in place, but I have never seen a case in which this was decided. But my personal opinion is it is a conflict of interest because it's a transaction that the board does take an action on, either exercising the right of first refusal in a condominium or accepting or rejecting the purchaser in the sale in a co-op. So I believe it's a conflict of interest, and I believe that a broker board member would have to recuse himself from that transaction.
So, and well, let me get to that because that is the next question. Okay, so you're at a board meeting, and there is a conflict of interest situation that comes up, whether it's this example that was just provided or it's the one that Ben mentioned earlier, where there's a board member who owns a plumbing company, and the board has decided to retain that plumbing company for certain work. What process does the board have to go through at that meeting so that this is properly disclosed?
Well, the first thing is the disclosure. So the board member who's got the financial interest and the conflict of interest has an obligation to immediately disclose to all of the other board members that conflict of interest. The board member, I believe, has a right to state his opinion because he's now disclosed that conflict, and all of the other board members know that may not be a objective opinion based on his position as a board because he has that conflict. Then, however, he must, particularly under the new law, he must not participate in the decision. He should not vote, and the votes of the remaining board members would be necessary for that action to be approved or disapproved. And with the new law, anytime there's such a transaction, you must record how each board member votes.
Yeah, and to kind of tie it all together, the conflicts of interest law requires that this is an annual report to all your owners. Certainly now it's just shareholders, but soon to be unit owners. So this is not just, okay, we followed this process at our board meeting. This is now going to be part of an annual report that you're going to, distribute to all your owners on an annual basis. So it's very important to understand this, make sure that you are following the processes, and a real good, worthwhile conversation with your general counsel, all right, to make sure that you are following this local law the right way. Because again, you do something that is just not in full compliance, at some point it's going to catch up to you, and it's better to get this thing right and make sure you have compliance early on, all right, because to go backwards is going to be very tough. I'm going to take questions in a moment, so I just want to finish the thought, and then we're ready to move on because we're getting close to the end. But so that really kind of, we covered the ground that we wanted to. I know we may have moved very quickly. Certainly, there could be lots of questions, but we'll take a few for the next few minutes until they cut us off. So, gentlemen, right here.
What level of detail would you like to see in the record decisions?
All right. So let me just repeat the question so everyone can hear it. The question is, what level of detail should be recorded on the decisions that are made? Is that correct? And is this around the conflict of interest or just in general?
Well, I mean, I think it's the same. The minutes should clearly reflect the decision. So what action has the board authorized? The discussion, the background, there's no necessity for that under any corporate law that I know of. It's the decision of the board. If there's a conflict, clearly.
Hello everyone, our next seminar will begin in about 5 minutes in room 1.
Okay.
Lower energy bills, improve resiliency,
well,
reduce your carbon
let's let
footprint.
that.
You
Let me
can
wait
have
for the
it
announcement
all
to finish.
Presented by Nyserta. Again, our next seminar will begin in about 5 minutes. Lower energy bills, improve resiliency, reduce your carbon footprint. You can have it all presented by Nyserta.
And so, to finish up the answer, and I think both cases, there's no need to, absent a conflict of interest, there's no need to record the vote. I would say if any board member says, I voted contrary to the decision and wants that in the minutes, I would put that in. Obviously, if there's a conflict of interest, then each board member's vote must be recorded. John voted yes, Bill voted yes, Jane voted no.
Okay, go ahead.
Okay, you were talking about following the rules of co-op. One of our big rules is that the shareholders elect a member of the board at the annual meeting. They nominate, they elect. We now are down 2 board members. We would like to use the self-nominating option where somebody submits a request to join the board and to possibly confirm the person as a member of the board of directors, because our next meeting is November. Is that
You've got to look at the bylaws, and I would consult with counsel to elaborate. The question was how to, absent between annual meetings when there's vacancies in the board, how can you fill them? Most of them allow the board to fill vacancies. Most bylaws allow boards to fill vacancies. It certainly would be permissible for the board to go out. We have 2 vacancies. Anybody interested, please submit your name, your resume, or what your reasons why to being on the board, and then have the board make the selection of the 1 or 2 people from whatever nominations that are submitted, or the board could go out and find 2 people that they wanted.
Okay.
Going back to conflict of interest, law, can you tell me what the local law is?
Okay, the question is, what is the local law regarding conflict of interest? Is that correct? Or-
It's actually a state law. It's the business corporation law. I don't remember the sections offhand. I'll give you a card afterwards, and if you send me a note, I will give those to you.
The husband of a co-op board secretary is a lawyer. Can he do work for the co-op on a pro bono basis? Can he do work on a fee basis for that?
The answer is yes and yes. The question is whether a spouse of a board member who's an attorney could do work either pro bono or on a fee basis. Pro bono, I think either way, because there might be a benefit, that sort of opens up that is a conflict of interest. Certainly if he's getting paid as a spouse of a board member, I think the board member's spouse has a financial interest. Separate whether that's a good idea or not. Again, because of all the political issues.
It's not illegal.
It's not illegal, no.
We're facing a situation where the shareholders, one below the other, we want a lower apartment, a small spot, and the apartment of basically the owner is whatever they want to do inside their apartment. So how does that affect us and how does both sides relate to us about harassing one or the other?
The question is upstairs, downstairs neighbors. The downstairs neighbor is smoking marijuana, creating odors that go into the upstairs neighbor. First of all, I should mention the smoking policy only deals with tobacco products and e-cigarettes, but this is whether this was marijuana, tobacco, or odors from things. You have what's probably covered under your bylaws of one owner creating a nuisance that's impacting on the other, and so is in violation of the bylaws. interactions between two owners is always a problem. You have legal rights. You should consult with your counsel as to how to most effectively enforce those rights as the board in dealing with this problem.
All right, we have time for one last question. I'm just moving to the back of the room.
On house rules, does the board need to enforce those rules from the outset, or enforce them when there's a problem? For instance, if you're talking about a percentage of floor covering for noise, does the board have to ensure that everyone is in compliance?
It's interesting because, okay, the question is, and this is the last question somebody from the who runs the room here told me, but I'm going to finish the question. The question is that if you have a house rule like carpet coverage within an apartment, and there's no complaint, do you enforce that? Right? If that's correct. And the issue is like, if we had the manpower to inspect apartments on a regular basis, maybe the answer is yes. And you expect the goodwill of your owners to follow the house rules, but in reality, we only know of a problem when there's a complaint, and then we can react to it. We just don't have the ability, neither do boards, to start inspecting apartments just to inspect apartments. Now, if somebody's doing an alteration, okay, at the end of an alteration, you can inspect the apartment as part of your follow-up and closing out that alteration to make sure that they have the proper carpet coverage, and that would be a great opportunity. But in the just sort of the run-of-the-mill day-to-day, it's a little bit difficult. But the key here is if you become aware of a situation, then you're required to react and take action.
That would be considered consistent.
What's that?
That would be considered consistent.
Yes.
In that case, that you enforce
Yes.
it as a problem.
Correct. That would be consistent in terms of taking action when you become aware of something. So I'm sorry that I couldn't get to everyone's questions, but I really appreciate you coming today, and I hope you had some good takeaways. Okay? Thank you very much.